Hello and welcome to our episode 3 of Crystalcast. My name is Ross and I am your immigration lawyer. This week we will be talking about a number of immigration and non-immigration related issues, and our topic of the week is labour agreements. But in addition to that, I do want to cover off the things that have been happening this week at immigration. I know there's a lot of questions that are popping up around state nomination allocations. We did touch on that in our episode 1. However, I do want to revisit that in light of further developments. We will also talk about potential options for business visa holders and also future business applicants. There's a question of the week and we've got our non-migration related topic. And this week I'm going to talk about what to look out for if you think that you are potentially getting scammed. And that is a big issue in our industry, both for migration agents, immigration lawyers, and also the applicants. So step back, relax, and enjoy the podcast. Now, this week in immigration news, there was an important announcement made by the Australian government, and that is the announcement of the new pilot called Innovation and Early Careers Skills Exchange Pilot. Now, just to tell you a little bit about what this is, it is part of the United Kingdom and Australia Free Trade Agreement. And the purpose of the pilot is to build an existing connections between Australia and UK by establishing a new and streamlined mobility pathway for early career professionals and in-demand innovators from the UK. Now, the way that this pilot works is that there's going to be 2 different visa streams. The first visa stream is the Early Careers Skills stream, which will allow participants to undertake short-term placement, a secondment, or an intra-corporate transfer for up to a year in Australia in the relevant field of their work in the sending organisation. And the second pilot, which would be probably more of an interest to individuals, would be the innovation stream, which allows participants with a demonstrated contribution to innovation to undertake opportunities in Australia for up to 3 years. Now, there is a little bit of a catch. The total visas available for this particular pilot in the first year will be 1,000. And in the second year, in 2024, it'll be 2,000. And under the current pilot, the program is due to be reviewed. Now, with any visa pilot, of course, it is a trial. So if it all goes well, we will probably see more allocations. Now, in terms of the early career stream, who is eligible? Now, if you are a UK citizen between the ages of 21 and 45, at the time of making the application, you hold a tertiary qualification, it could be a bachelor degree or diploma, and have worked for a minimum of 3 months, you would be eligible under this stream. Now, that's a great alternative because if you look at other visas such as a training visa or a 482 visa, it generally does require you to have at least 1 year work experience and 2 years if you are applying for a sponsored visa. Now, when we look at the innovation stream or the innovator stream, to be eligible under this program, the applicants must be highly experienced and skilled UK citizens from any sector with a demonstrated contribution to innovation in the area, including but not limited to research and development, renewable energy, artificial energy, medical technology, fintech, agri-tech, and audio and visual and cultural industries. So this is a great new initiative. Now, whilst the numbers might appear to be small, what's really good about this particular pilot is the fact that it allows individuals who are at the start of their career to be able to utilize their existing skill set to move to Australia and utilize that skill set in order to develop further. Now, can employers benefit from this particular pilot? Absolutely. Now, this pilot recognizes the importance of innovation and skills mobility to the economies of both Australia and the UK. This pilot will provide Australian employers with an opportunity to access innovative and early career professionals from the UK through the pilot of a new streamlined temporary mobility pathway from the UK to Australia. UK organisations will benefit from employee upskilling as well as a way of providing key staff with an international career development and opportunity. Now, the innovation stream specifically will provide unique opportunity for highly experienced, skilled UK innovators to work in Australian organisations for up to 3 years, including through intra-corporate transfers, and the early career stream will give Australian organisations to participate in 12-month secondments and placements in intra-corporate transfers. Now, there are no minimum salary requirements set for either stream. The requirement is that those who do move to Australia and are employed on a full-time basis would be paid according to the national employment standards. The other benefit of this particular visa is that it's not a sponsored visa, so therefore there would be an opportunity for these individuals coming to Australia under the UK and Australian pilot to be able to utilise their skills across multiple employers. Now let's talk about question of the week, and the question of the week is, how come certain applications lodged with the Department of Home Affairs are decided sooner than other applications? And this question comes up on a regular basis, and this question has come up for me a number of times this week, therefore it's a relevant topic to discuss. Whilst the processing times are getting better, there's definitely an acknowledgement that should be sent to the Department of Home Affairs or given to the Department of Home Affairs. It is getting better, but there is still that inconsistency. So why do some applications get a decision sooner rather than others? Now, the way that the processing of a visa application works is that there is what's called a collective case management system. Now, it's important to understand what is a collective management case system. And the reason why that's important is because when you lodge your visa application, or if you lodge your visa application on behalf of your client, the application doesn't get allocated to a case officer. So essentially it sits in the IMI account, or if it's a paper-based application, it is in the queue to be allocated. Now, each team, depending on whether you lodge a skilled visa, whether you lodge a family visa, a work visa, would have different allocation centers, and they would have different processing teams assessing these visas. So for example, let's say that there is 1,000 TSS visa applications lodged today. Now, these applications would be allocated to different processing centers, and depending on the capacity of that processing center, some processing centers would be able to get through the work quicker, whilst others might take a little bit longer. So things to remember is, just because someone's application was approved sooner and your application's taking a little bit longer to process, it doesn't mean that there is anything wrong with the application. And when you look at the processing time listed on the department's website, it does give you a fairly broad range, which some may not find helpful, but that's important to understand that certain cases may take a week or perhaps 2 weeks to process, whilst others in the very same category take 2 months to process. So what can you do to speed up the process? Well, the short answer is there's nothing that you can do. There is no avenue to follow up on an application or to send an email to the Department of Home Affairs and asking for an application to be expedited, unless it is a type of application that can be expedited. And that would be generally in situations where the visa's been cancelled and someone is an unlawful non-citizen. There is just no way to have the application expedited. So what can be done? Well, first and foremost, ensuring that the application is decision ready. I fully appreciate it. We want that application lodged as soon as possible, have it in the queue. However, if you are missing a document or 2 documents, waiting that extra day to ensure that the application is decision ready is paramount. So decision ready application means that all of the documents are there and there is nothing outstanding. Don't get your documents ready too early. Now, for example, if you're working on a permanent residency application and you know that it's going to take you a month or two, or maybe even longer to put together, factor in the processing times as well. For example, time-sensitive documents such as police checks are valid for 12 months from the date of issue. So if you're lodging an application such as a partner visa that can take over 12 months to process, you may wish to get time-sensitive documents closer to the date that you think your application is going to be decided. So these are the elements that you can take into consideration when you lodge an application, ensuring that it's fully documented, ensuring that your time-sensitive documents are obtained at the relevant time, and also be aware that some applications may come through sooner, whilst others may take a little bit longer, but it's certainly not a reflection that there is anything wrong with the application. Now, on to my favorite part of the podcast, which is topic of the week. And this week, I'm going to be discussing labor agreements. Now, there's been a lot of interest in labor agreements, both from employers, registered migration agents, immigration lawyers, and also the applicants themselves. So what I wanted to do is just to give a brief overview of what is a labor agreement, why there is that interest in labor agreements, and what you can do in order to look into the process a little bit further. So first and foremost, a labor agreement is an agreement negotiated between an employer and the Australian government. That may be the Immigration Minister or the Minister for Employment. Now, the idea behind a labor agreement is to offer a sponsored pathway for an individual to remain in Australia, but more importantly, it allows employers to access skilled and semi-skilled labour, which may not be available in the Australian market. Now, there's a couple of points to note here. We do have quite a low unemployment rate at the moment, and whenever there is a low unemployment rate, that generally translates to the fact that we don't have much of a skill that is available to employers. Now, that's not to say that the unemployment or people that are unemployed do not have the skills, but it's to say that when we look at different industries, there's just a skill shortage. So, for example, looking at the hospitality industry, looking at construction industry, there are severe skill shortages. And most importantly, when we look at regional areas, so when it comes to regional areas, remove Sydney, Melbourne, or Brisbane, these areas suffer from a massive skill shortage. So the idea behind a labor agreement is to facilitate that gateway between being able to access skilled labor or access to foreign nationals who would be able to fulfill that role. Now, there are three parts to a labor agreement. The first part is the negotiation stage, and that part involves an employer negotiating a labor agreement with the Australian government. The employer would have to put forward the occupations that they would like to access and the reason why they would like to access those applications. Now, it's not as straightforward as just putting forward a request and saying, I would like to have access to a myriad of occupations. There needs to be a strong business case. Now, the second part is the consideration of that labor agreement. And the consideration is the Australian government reviewing the information that's received by the employer and making a decision to see whether the labor agreement is viable. So to give you an example, if a business employs 100 employees and they want to put in a labor agreement and request 20 skilled and semi-skilled positions, that could be okay. There may not be an issue with that, provided that they meet other requirements, being lawfully operating in Australia, having a good financial standing, and also having around 70 to 30% ratio of Australian staff to foreign staff. And if the occupations that are being requested make sense to the business, so they fit within the nature and scope of the business, then the consideration stage will most likely be favorable. Now, there are some other hurdles, including negotiation with peak industry bodies, depending on where the business operates. But essentially, if the negotiation stage goes well, then the Australian government would be able to put forward the final proposal to the employer, and offer an agreement which may have all of the positions and all of the conditions as well that the employer has requested, or perhaps entertain some of the request, or the positions or the conditions that the employer has requested. So going back to the example of requesting 20 positions on the labour agreement, the government may agree to 10. Now, what are some of the advantages? An employee can request permanent residency for all of the occupations. An employee can also request concessions. For example, these concessions may include a lower skill threshold to perform a particular occupation. An employer may request a concession in relation to a salary. Now, the current salary for sponsored visas sits at $70,000 per annum, excluding super. So there is a leeway to request a reduced salary, and that leeway will depend on what would be the appropriate market rate. Generally, the government would not go below 15% of the minimum salary threshold, being 70. However, depending on the industry that your client operates, there may be further negotiations. And more importantly, English language concessions as well. For example, where there's a role that is a non-client facing role, so it might be technical, it might be trades, there are some concessions around that element as well. And last but not least, access towards permanent residency. Now, we do in Australia have different occupation lists that allow employers and also visa applicants to either have access to temporary residence or permanent residency, or both. Now, the wonderful thing about labour agreements is that it is possible to request access towards permanent residency. And if there is a particular role that the applicant would be performing or the business needs, it's also possible to create an occupation or perhaps combine an occupation and create a hybrid occupation. So there's definitely a lot of flexibility around what can be done with labour agreements. It is quite a labour-intensive process, if you will, but in having said that, the benefits definitely do outweigh any detriments that might come with it. And well, I wouldn't even call it a detriment, I would call it more of a challenge in putting together such application. But if you look at the order of processing of these applications, labour agreements sit on top of the priority with the Department of Home Affairs. So once your client receives a labour agreement, they would have their nominations streamlined. So in most cases, it would be an auto grant of the nomination, and the visa applications are also expedited. So labour agreements, who are they useful for? They're useful for all types of businesses, but particularly if your client operates a business where there is a need for skilled or semi-skilled labor, and also if your client is operating in an area that might be remote or regional. And as I mentioned before, in Australia, regional area is anything outside of Sydney, Melbourne, or Brisbane. So therefore, there are a number of employers who would benefit from labour agreements. Now, if you do want to know more about labour agreements or learn how they work, you're more than welcome to get in touch with me, ross@crystalmigration.net, and I would be able to provide you more details. Now, there are still concerns around the lack of allocations for business visas, subclass 188. If you recall the discussion that we had in episode 1 of our podcast about state allocations, all states and territories have received no allocations for business visas. Now, the reason for that is because the Department of Home Affairs has enough applications on hand for 188 visa subclass in order to fill in the allocation for this financial year. So the problem with that is that it doesn't open up doors to any potential new business owners or investors. And I have received a number of calls and also emails as to what the options might be. Now, there are a number of different options for Australia. There are over 90 visa subclasses, but I understand that when it comes to dealing with business visa holders and business visa applicants, it is a very specific category, so maybe a skilled visa may not be appropriate in this particular instance, and also an employer sponsored visa may not necessarily work. However, if there is a genuine intention for a business owner to establish an entity in Australia, one of the potential options that could be looked at is an overseas business sponsorship, and that's something that I wanted to briefly discuss. Now, an overseas business sponsorship works differently to a standard business sponsorship. So to give you an example, if there is an overseas business that wants to either one, establish a business in Australia, or two, fulfill a contractual obligation, they could make an application for an overseas business sponsorship. Now, the application would need to be made by the overseas business, not the Australian business, and that facility would then allow an employee of the foreign business to be able to travel to Australia to either establish a business or fulfill a contractual obligation. Now, there are some drawbacks with this particular option, and the main one is that once the applicant is in Australia as a holder of a 482 visa in the overseas business sponsorship stream, they do need to be an employee of that business. So therefore, they will be subject to certain visa conditions and limitations, including running of the business in Australia. However, in having said that, given that there are no allocations available for business visa holders, we do need to look at other options that might be available. So if you've got clients that are looking to set up a business in Australia and remain in Australia in order to work for that business, then potentially an overseas business sponsorship could be an option. So just to recap, an overseas business sponsorship is available to foreign businesses that want to open up a business or a subsidiary in Australia, and the purpose of that would be to establish a business in Australia or to fulfill a contractual obligation. Now, for this week's non-related migration topic, I wanted to discuss something different, and that is Scam Alert. This week, I had a very interesting encounter. I was contacted by a person that I have no affiliation with, and that person mentioned to me that I was shortlisted for a particular award, never entered into any competition, and it was just one of those cold leads. And the long story short, given me this whole spiel about winning the award and how this award is so prestigious, and there would be a ceremony and that there is a selection process. Now, I thought, well, look, why don't I see how it goes? And I've contacted this particular individual and said, not a problem, happy to set up a call with you. Now, I have to admit, the call was a little bit odd because I was contacted by one person, and then I received calls from what appeared to be two different jurisdictions, one from America and one from another jurisdiction. It was really sort of pushed upon me, have this call. So I finally ended up having a call. It was a Zoom chat. The screen was blurred, so I couldn't really see what was happening behind the scenes, so to speak, and who this individual was. Now, the call started off very odd as well. Rather than discussing how I was selected for the award and what the process entailed and what this award ceremony is, I was talked more about why this business was legitimate, which I thought was very odd. if I have won things in the past, and generally you don't talk about, what the organization is. You talk about the award itself, how to attend, etc., etc. So we spent about 10 minutes discussing what this organization does. They were showing me random clippings of magazines, and they've taken me to a Dropbox to show me photos from what appeared to be previous conferences, and just sort of name dropping. And these individuals had no connection with my industry whatsoever. And then towards the end, it was asked that if I could just pay $2,000, I would be able to be vetted to the next process. Now, you know that gut feeling when you just know that something doesn't feel right? I had that throughout the entire call. And when the call finished, well, the way that the call finished, it just wouldn't. So I said to the person that I was speaking with that I need to think about it and I'll come back to them. Now they told me that I need to hurry because there's apparently 1,500 other people that they are considering. So I thought, well, great, they're not short on nominees, so they're not going to miss me. But what was really interesting is that this particular individual then contacted me on WhatsApp, and they were just sending me unsolicited messages. And straight away I thought, well, if there's 1,500 people that you are considering, surely I'm not that special that you need to just chase me down and try to call me at odd hours as well. I understand that there's different time zones, but it just didn't feel right. Now, I did what anyone would do. I've Googled this particular agency, and it would appear that there are multiple complaints made against them, and it is exactly the same way. They contact you via social media to say that you won a particular award or you've been given a role to speak at a particular event, and they request a deposit and also a ticket fee, and then they request you to fly to another country. Now, obviously, anyone would get skeptical over that, and whilst the website that I was directed to did look legitimate, it looked like a website. There was just no evidence that there were any conferences held in the past. All of the conferences were booked into the future, so that was another red alert. And yesterday, once again, I received another call from this particular individual, and I just had to say a very firm, I'm not interested, please do not contact me. And this just shows that scams exist in all forms, and the challenge that we have, one of the main challenges that we have, is that our lives are on social media. Now, I do like to keep my personal life and professional life separately, but unfortunately, in this particular instance, this individual has reached out to me via LinkedIn, and I am quite active on LinkedIn. And it was just one of those unfortunate situations where they've looked up my employment history and thought that I would be a good candidate to approach. But nevertheless, I have found a number of similar situations where individuals have reported being contacted in the same manner and then just being demanded for money, and the ceremony or the event never took place. So just be careful when individuals contact you. I have read and I've discussed things like that with a number of colleagues, and the bottom line is, if it sounds too good to be true, it probably is too good to be true. And always go with your gut feeling. If you feel that you're in a situation where something feels a little bit off, trust your gut instinct. Now, I do want to thank my Melbourne colleagues for coming together last week to our first face-to-face CPD session held in Melbourne since the COVID pandemic. Now, the pandemic has halted continued professional development and moved it online, which is great. It allows individuals to connect from different time zones, from different cities at the same time, and engage in fruitful discussions. But I do have to admit, there's nothing that even compares closely to face-to-face learning. engaging questions, fruitful discussions, being able to ask questions in real time, being able to engage in different subject matters in real time, and then just being able to connect with colleagues that you may not necessarily be able to see on a day-to-day basis. So again, thank you, Melbourne, for welcoming us. It was great to see a good turnout, and I will definitely be back there as soon as I can. Now, if you are a migration agent or an immigration lawyer and you do want to attend a face-to-face CPD session, there is a face-to-face CPD session coming up in Adelaide in October, followed by Perth in November, and we will wrap up the year in December in Brisbane. And if all goes well, I'm hoping that face-to-face CPD sessions will continue. I think the way that the pandemic has changed the way that we work, the way that we learn new things, will probably remain for some years to come. Online learning is great. Podcasts, all of that is great. However, nothing beats that face-to-face contact. So if you want that face-to-face contact, visit www.crystalmigrationtraining.com.au. That's www.crystalmigrationtraining.com.au and click on face-to-face CPD sessions to book a session in a city near you. And that's all the time that we have for this week's episode. First and foremost, thank you very much for supporting our channel. Please like and subscribe to our channel to get the latest updates when a new podcast episode goes up live. If you do want to be featured on our podcast, please send us an email, ross@crystalmigration.net. That's ross@crystalmigration.net. During the season, we will have guest appearances as well from other practitioners and other speakers as well, which I look forward to. And if you have any suggestions, you are also more than welcome to send me an email. Have a good week ahead, and I look forward to seeing you at our future podcast episodes.